Thank you for the wonderful introduction, Rob. As Rob said, my name is Maria Panichelli, and this is my colleague, Bob Ruggieri. We are both in the government contracting group at our firm, Cohen Seglius, which means that we focus exclusively on federal government contracting, seeing contractors through every cycle or every stage of the life cycle of their government contract, from the pre-proposal and pre-award stage, interpreting the solicitation, any bid protests that might come up, et cetera, then through the performance stage, dealing with performance and compliance counseling, then through, of course, the dispute resolution stage, if there's any need for claims, REAs, anything of that nature. Another big part of what we do relates to compliance and small business regs, dealing with eligibility and certification concerns, teaming, joint ventures, mentor-protege. Basically, we run the gamut. If it has to do with federal government contracting legal needs, you name it, we do it. So we focus, like I said, exclusively on federal government contracting, but our firm is a full-service law firm. It is spread across 9 offices. We've got offices in 6 states and in the District of Columbia, and we offer any number of legal services, whatever you guys need. We do, that being said, have a specific kind of focus or specific expertise in construction contracting because our firm actually began as a construction boutique law firm. There are members of our practice group that respectively worked for the Corps of Engineers in their district council office for, combined total over 50 years. So when it comes to federal contracting, but specifically federal government construction contracting, we really know what we are doing. What we're going to be talking about today is an issue that kind of spans across our nationwide client base. We represent both primes and subs. We're going to be talking about some of the key issues and considerations, that come up when you're talking about federal government contracting and specifically federal government construction contracting. So one of the things that we're going to talk about is flow-down clauses. Then we're going to go over some key FAR clauses. Then we're going to move into subcontractor claims against the owner, which are commonly known as pass-through claims. And then we're going to move on to subcontractor claims against the prime and to the Miller Act claims, which are a specific type of claim where you go after the surety in construction contracts. All right, so I want to dive into the first part that we're going to talk about flow-down clauses. But I want to just real quick, how many of you out there do primarily prime contractor work, federal government contracting? All right, and how many of you do primarily subcontractor work? All right, and how many of you do both? All right, so we got a good mix in here. We're going to try to cover all of these issues from both points of view. Now, that being said, a lot of what subcontractors have to think about kind of necessarily is informed by what the prime contractor is going to be thinking about. So when the government's telling the prime something, what is the prime then going to tell the sub? So we're going to hit it from both angles, but a lot of what we're going to be doing is coming at it from the point of view of the prime, at least for the first half, because that's going to inform the way that they interact with their subcontractors. So with that, FAR flow-down clauses, or flow-down clauses in general, are a really big and important topic when you're talking about federal government contracting and subcontracting. Now, these concepts aren't necessarily unique to the federal government sphere. Anytime you've got a subcontract-prime contract relationship, there's going to be some back and forth, and the fundamental concept of negotiation and what discussions happen between the prime and the sub are going to be considerations. They're going to be things that you need to keep in mind. What makes it unique in the federal context, though, is when you're talking about subcontractor and prime negotiations, each situation is going to be a little bit different. It's going to be different who's got more bargaining power, who's got the leverage, how much more leverage they have, etc. When you're talking about subcontracting in the federal sphere in particular, the prime contractor has a lot less flexibility because their contract is with the federal government. There are very strict regulations and requirements in place with the FAR, etc., that are going to dictate what the prime contractor can and can't do. Which means that unlike some state and local contracts, or especially in the private sphere where they have a lot more room to negotiate, primes aren't going to have as much negotiation room or as much wiggle room or as much ability to change requirements, which is why it's important to keep that in mind and why subs need to keep that in mind when they're trying to negotiate subcontracts. So in the unique world of federal government contracting, flow-down clauses can be critical. And when we say flow-down clauses, what do we mean by that? Well, in the strictest sense, flow-down clauses are clauses that are part of the prime contractor's contract with the government that are then incorporated, sometimes verbatim or cut and paste or tweaked just slightly, into the contract with the subcontractor. They are flowed down. Now, that's technically speaking. A lot of times when you hear the term flow down used, it's used kind of more as a catch-all to talk not only about those types of clauses that are moved verbatim, flowed down verbatim, or just slightly modified from the prime contract to the subcontract, but also to kind of incorporate any other sort of risk shifting provision that's in a subcontract where a prime contractor is trying to kind of accommodate what their risks are or their concerns are and flow it down to the subcontractor. So why do these clauses matter? We're going to start, like I said, we're going to look at this from both points of view, but we're going to start kind of looking at it from the prime contractor's point of view. The flow down clauses, both in terms of just strict flow down clauses and risk shifting provisions, et cetera, matter because communication breakdown can often cause notice failures. As many of you who are doing business with the federal government know, when you're talking about changes or differing site conditions or the different types of issues, delays, defective specs, et cetera, that arise when you're performing a job, a lot of those have strict notice requirements that you have to comply with if you want to preserve your rights to claim later or even to be in a good position to negotiate an REA later. If your sub's not aware of those can be a problem. If you're the prime and you don't have proper flow down requirements, that can sometimes cause a default. Remember, if you're the prime contractor, the government's looking to you. They're not interested in excuses. Well, my sub's not delivering to me, I'm not able to keep my sub in line, etc. They're going to look to you to successfully perform and complete the job. They're going to look to you and hold you responsible for any issues you have with your sub. So you're going to want to make very sure that you don't get stuck in the middle where you're fighting a battle upstream, apologizing or trying to fight with the government about money that you might be owed or days that you want to extend the contract for excusable delays, et cetera, while also trying to fight your subcontractor below you. Generally speaking, what primes are going to try to do is make sure that they are not stuck in the middle. They never want to be fighting a battle on both fronts. That's always a difficult position. It's even more when you're dealing with the federal government on one of those fronts. So I'm going to give you an example, and this happened to a client of ours several years ago. And again, from the prime contractor point of view, we're going to talk about the subcontractor point of view in just a few slides. But terminations for convenience, a clause that is in, as a general matter, every single government contract that's out there, right? The government's always going to have the ability to terminate the prime contractor for their convenience. Now, for those of you who aren't familiar with that concept, that doesn't mean there was a default. It doesn't mean that the contractor did anything wrong. It means that the contracting officer has determined it's no longer in the best interest of the government to continue with this particular requirement. Maybe it was a construction project in an area that they no longer want to build, in a conflict area overseas. Maybe that they've run out of funding. Maybe a change came up in the contract, and in order to fix that change, it would put it out of budgetary range. These are all the types of things that can lead to a termination for convenience. But let's say you're a prime and you're working with the Corps of Engineers, just by way of example, and they turn around and they say, we're going to take advantage of the fact that we can terminate you for convenience. Don't worry, you're going to get paid for your costs expended, but we're not going to finish the job. You're done now. Thank you very much. No smear on your record, but please move on. Well, we had a contractor who had that situation come up, but they had not come to us, unfortunately, before they did their subcontract. They were not able to turn around to the subcontractor and then say, great, we flowed down the terminations for convenience clause to you, so since we just got terminated, now all of you guys are too. So what ended up happening to that contractor is they were dealing with subs, and the subs said, well, I'm sorry you've been terminated, but you don't have a right to terminate us. You owe us the balance of our subcontract that we entered into. That's an example, the type of thing that you need to be considerate of when you're a prime contractor. If the government has the ability to withhold money from you or stop performance, you need to be able to flow that down so that you're not stuck in a position where you've been terminated, but now you've got all these subs that even though you don't have money coming in, means that you're not going to get paid, means that you have to still pay them. One way to deal with it, and from a subcontractor's point of view, if you're a subcontractor out there, or if you do subcontracting work, the reason that this is important is when you're trying to negotiate a subcontract, most prime contractors, if they've thought enough to think to pass this through, you're not going to have a lot of wiggle room. This is one that prime contractors aren't going to want to get rid of. But what can you do? If you understand where they're coming from, if you understand, okay, prime contractor doesn't want to be stuck in the middle, doesn't want to be terminated by the government, but I still get paid. Maybe you can negotiate not just a straight termination for convenience clause, but a conditional terminations for convenience clause. In other words, you can't terminate for convenience just because you've determined that this isn't in your prime contractor's best interest anymore. You can only terminate me for convenience if you've been terminated for convenience. So that should take care of the prime contractor's concern, but also gives you as the subcontractor a little bit of something to work with. Again, from a subcontractor's point of view, all about understanding the limitations and restrictions and concerns of the prime and understanding what wiggle room you're going to have to negotiate within those parameters. So if you use that example of the prime contractor that came to us and got stuck in the middle, we were able to negotiate with the subs and reach a favorable resolution, but you don't want to be in that situation. You want to be able to say, nope, sorry, we flowed that down to you. You're all terminated for convenience as well. What you need to think of if you're a prime, the lessons that you want to, take away from this are, okay, what are my obligations to the government? What are my obligations to the owner on whatever project I'm working on? How could the subcontractor or whatever subcontractors I'm using or suppliers I'm using, how could they impact my ability to deliver what I'm required to deliver to the prime? Number one, are there any things that I need to flow down? Are there things that are, termination for convenience that I should think about flowing down or think about flowing down in some form? How can I protect myself from fighting a battle on both fronts? So you're going to protect yourself by flowing down obligations, making sure that the obligations are consistent. By that I mean make sure the sub is obligated to you to the same extent you are obligated to the owner. You don't want to have it that the sub's responsible for doing something. You have much more onerous requirements. Therefore, the sub gets you something that's subpar as compared to your own obligations to the government. Plan ahead to avoid being caught in the middle and having a battle on two fronts. And all of these things are things you're going to want to carefully think about when you're drafting your subcontract. All right, so now let's take a look from the other point of view. Let's talk about what this means for subcontractors. Subcontractors need to know what their obligations are and what procedures they need to follow. Now, the primes, especially if they've done business with the government before, are going to know a lot of the key clauses, are going to know a lot of the key concepts, differing site conditions, defective specs, changes, delays, inefficiencies, etc. They're going to know those things and they're going to be familiar with them. Subs may not, or especially subs getting into the, this area for the first time might not know as well what they need to do. So you're going to need to be aware of what your obligations are and what procedures you have to follow. And in order to be aware of those, you need to know which clauses have been flowed down and which obligations those clauses impose. Also need to keep aware of what other risks have been shifted. Here's an example of exactly what you don't want to do as a sub. We see these all the time. This is the most common mistake that we see subs make when people come to us later in the process. See a clause like this in your subcontract, and we've underlined the important part because if I just read all of that legalese, your eyes would all glaze over and you'd all be out of here. But the important part here is that it says the subcontractor shall assume to the contractor all obligations and responsibilities which the contractor assumes towards the owner. So that's great. That's consistent with what we said on the previous slides. The prime's trying to make the sub responsible to them to the same extent that the prime is responsible to the government. But what's the problem? The problem is the prime knows what's in their contract. The prime knows how they're obligated to the government. The sub, if that's all they see, the sub doesn't know what they just agreed to. They just agreed that all of their responsibilities mirror whatever in the prime contract. They haven't seen the prime contract. They don't know what they're mirroring. So we see subs all the time that sign something like this. It's standard, it's boilerplate, it's in a lot of contracts. But the problem is they don't know what they actually just agreed to. They know that they agreed to be the same as something. But because they don't understand what that something entails, they just agreed to a whole bunch of stuff that they're not clear on. Perfect example. Another case where, in this case, we represented the prime, but the problem arose because of a sub. It was a differing site conditions case. Hospital where part of the project was supposed to be asbestos abatement. Unfortunately, asbestos abatement turned out to be a much larger portion of the project because there were differing site conditions. Now, the prime, incredibly experienced federal government contractor, knew what they had to do in terms of giving notice for the differing site conditions, so they thought everything was covered. But they had a general flow-down clause like the one we just saw on the slide before. Their sub didn't know. Their sub gave notice once. They walked into one room. There was extra asbestos in that room. They then thought they had covered their notice requirements. They went from room to room to room. There was additional differing site conditions. There was additional delays. They weren't giving the prime notice, so the prime wasn't giving the government notice. So when down the line it came to do a claim, which we're going to talk about later, the government turned around and said, we never got the requisite notice. I'm sorry, how do you expect us to pay you when you weren't following the regulations? And if you look at the differing site conditions clause, you can see you can be entitled to a request for equitable adjustment. In other words, they'll adjust the contract price up for a differing site condition, but only if the contractor has given the written notice required. So again, that's one of those things where failure to communicate, failure of the sub to understand what it's signing off on means that both the sub and the prime are in danger, because the government can turn around and say, no, I'm sorry, you didn't fulfill your end of the bargain, you didn't meet the notice requirements, I'm not going to honor any REA or claim that you put in. Now, again, because we worked with that agency and those government people and those particular clients before, we were able to negotiate something that worked out, but you never want to be in that situation. If you're a sub, you want to be sure what you're agreeing to. If you're a prime, you want to be sure your sub knows what they're agreeing to, because it could get you in trouble as well. So takeaway lessons for subcontractors: always understand what you're agreeing to. Make sure you know what obligations and responsibilities and procedures you are bound by. Never accept a vague flow-down clause. To the extent that you've got a flow-down clause that references prime contract documents or references some other source document, get a copy of those documents. If there's a security clearance issue, then definitely don't agree to a clause that references a document you can't see. Say, okay, I understand, prime, what you're trying to do here, but if I can't see your clauses, I can't see your prime contract, I understand you're not allowed to share it with me, you've got a confidentiality agreement or, a security clearance issue, fine, but then you need to put in specific terms in the subcontract what you need me to do, as opposed to referring to a document I don't have access to. Flip side, advocate that the prime's responsibilities to you mirror the government's responsibilities to the prime. It's not all about what you want, what the prime wants of you, it's about what you get in return. And again, always carefully craft your subcontract to address these concerns. Or at least make sure, at the very least, if you're a subcontractor that maybe doesn't have as much leverage as you'd like, make sure that you're at least at a minimum clear on what your responsibilities are with regard to procedures, notice, etc. So, how to determine what to flow down? There are some clauses that are mandatory. In other words, the FAR clause itself, if you're a prime contractor, will tell you you need to flow this down, especially if, for those of you who do any commercial contracts, there's a whole list. If you're interested, we can get it to you. Contact me after the presentation. The FAR, like I said, itself will state that these things are mandatory. You have to flow them down. Common misconception, mandatory does not mean automatic. In other words, if the FAR says you have to flow this down, that's an instruction telling you it's mandatory. It's not something saying, therefore, it's automatically done. You can assume that it's in there. And you're always going to want to consider whether you flow down the clause, in other words, take something verbatim and move it down, or if you just flow down the substance and spirit of the clause and tweak it. Like I said, using the terminations for convenience example, don't flow it down verbatim. Maybe say only if I've been terminated as the prime, do I have the right to terminate the sub. These are just some critical flow down issues you need to be aware of. If you are a prime or a sub, you want to think about how changes are dealt with, how differing site conditions are dealt with, how the notice provisions regarding both of those are dealt with. Dispute resolutions, claims, certification, and we're going to talk about that when we get to the pass-through section, as well as payment timing for those of you who live in jurisdictions where pay if paid or pay when paid clauses are enforceable. I'm going to talk to a legal professional about whether they are. That might impact how you structure the payment clauses, suspension, and of course, terminations. And again, they're all very fact-specific. I would suggest that you talk to a legal professional, someone who's familiar with federal contracting, and they can help you tailor all of those things to help you in whatever specific project you're going after. So with that, I'm going to turn it over to Bob to handle some of the key FAR clauses on construction contracts.
All right, thank you, Maria. So now that we've discussed flow-down clauses and what they mean, I just want to take a few minutes to discuss some of the most important FAR clauses that you're going to find in your construction contracts. These clauses are going to be in your prime contract, or if you're a subcontractor, they're most likely going to be flowed down to your subcontract. And as a subcontractor, you also want to be familiar with them because, as Maria said, they're important for pass-through claims that might come up later. You should expect that all of these FAR clauses that we're going to go through in a minute are going to be in your prime contract, and even if they aren't expressly written in your contract, there's a doctrine known as the Christian doctrine from a case in the 60s, which held that key construction contracts or key contracts in general are going to be read into your contract even if they're not specifically there in writing, like the changes clause or the termination for convenience clause. So it's in your contract even if it's not in your contract, especially if it's a particularly important one. Another thing, before we dive into the clauses, I do want to point out that what's a common theme in all of them And that's the importance of documenting the important events that occur on a construction project and providing any timely notice that's required by those clauses. By properly documenting events as they happen, as they occur, and in a timely notice, providing the notice to the government, you're going to give yourself the best opportunity to preserve your rights, especially your rights to payment, and avoid confusion and disputes later down the road. The first clause I want to talk about is the changes clause. I'm sure you've all heard of it. Most of you are probably very familiar with it. It's probably the most utilized and litigated FAR clause out there. The changes clause allows the government to make changes to the general scope of a contract, including modifications to the drawings or the specifications, and even in the manner or the performance of work. A change could be a direction to accelerate work. But it also requires that the government make an equitable adjustment in the contract price as a result of those changes. The first and most obvious change you're going to see, and the easiest to spot, is a directed change. It's called a change by the government. Generally, the government will ask for a proposal, and usually the parties are going to reach an agreement on a modification for any additional costs that result from that change. If the parties can't agree on a specific adjustment for a directed change, the government will typically issue a unilateral modification, and the contractor will be able to assert later a claim if they believe they're entitled to additional compensation beyond the amount in the unilateral modification. The more challenging situation occurs when there's a constructive change. Now, the clause doesn't indicate or doesn't use the words constructive change, but constructive changes are recognized in the law as a remedy that's afforded for when there's a change that's not expressly directed in writing by someone from the government. It could be any written or oral direction provided by the government that affects a change. And under the language of the clause, such changes are treated as a government-ordered change, just as if they were in writing, and the contractor will be entitled to an equitable adjustment for these types of changes, just as they would be for a specific directed change. It's important for contractors to be aware of the occurrence of these constructive changes, because once a contractor believes that an oral written statement is a change to the contract, it should immediately notify the government in writing of the change. Generally, no adjustment will be given to the contractor for costs that were incurred more than 20 days beyond the time you gave a notice. So when you give a notice of what you believe to be a change, you're only allowed to look back about 20 days. Costs that you may have incurred as a result of that change beyond 20 days might not be recoverable. So as soon as you think there's a change, make sure you document it and provide notice, or you could be losing your right to an adjustment for costs that occurred before more than 20 days. Whether it's a directed change or a constructive change, of course, it's important to keep track of all the costs you believe occurred directly as a result of that change. Maybe open up a separate accounting code, but whatever, keep those costs separate so you can present them clearly and easily down the road. There's another requirement for a notice. Once the change is complete, you have 30 days to provide a notice of or your request for an adjustment as a result of that change. So there are two notices. One, when you believe there's a change. Two, 30 days later, when you're in a position to request an adjustment to the contract. It's critical also to remember that only the contracting officer can issue a change to the contract. Following direction from anybody else, you're going to be doing it at your own risk, and you might not be able to receive an adjustment if you followed direction that was a change from someone other than the contracting officer. One final thing, it's important to continue to perform the work diligently while negotiating a change. And unfortunately, you might have to finance a change for a certain amount of time until you're able to reach resolution, but the clause specifically requires you to proceed with the work in spite of a change. Another hotly debated and clause is the differing site conditions clause. This comes up a lot on construction projects. The clause, what it does is place the risk of unknown site conditions onto the government. This allows contractors to avoid having to place contingencies in their bid for such unknown conditions, thereby keeping their bids lower. As with the changes clause, it does provide a mechanism for an equitable adjustment when the contractor incurs additional costs as a result of a differing site condition or delays. There are two types of differing site conditions, creatively referred to as a type 1 and a type 2. Type 1 is a comparison between what the contractor experiences out in the field versus what the contract documents say, whether it's boring logs or specifications. So it's comparison to what you're encountering versus something that was written in the solicitation and contract that you relied upon. Most common typical example we see, maybe there are borings in the contract specifications that do not indicate the presence of rock. Contractor goes out there, is excavating, hits hard rock, and of course that takes a lot more time and a lot more money to perform. So that's a type 1 differing site condition, because your contract didn't indicate rock, but you encountered it. When dealing with a site with a type 1 differing site condition, it's important that the condition be reasonably unforeseeable to the contractor and that you reasonably relied upon the borings or whatever other information to the contract and you were damaged as a result of that reliance. So if you never looked at the borings or never considered them or never asked for them, even though they're available, you might not be able to recover for differing site conditions because you didn't rely on that information to your detriment. Another good point, though, is a contractor is not required to make additional investigations on its own to verify the accuracy of maybe subsurface information. So you're allowed to reasonably rely on that information. And you're also not required necessarily to hire a geologist or make extensive engineering investigations to confirm the accuracy of the information. So you are allowed, the provision does give you the right, and the law gives you the right to reasonably rely on the information you provided. The type 2 differing site condition is where you're not relying on information in the contract, but the conditions you encounter are just different than what you would normally expect, maybe in that particular location or geography or in the type of work. Let's say you're digging in a field, you're excavating, and you hit unforeseen concrete vaults underground, which there'd be no reason for you to expect them to be there. That would be a type 2, because there's nothing in the contract that you relied on saying whether they'd be there or not, but it's just not common, maybe in this particular area, to find such structures under the ground. So that would be a type 2 differing site condition. As with changes, notice is critical. The clause requires the contractor to give prompt notice to the government of a differing condition or what it believes to be a differing condition, and then stop work and not further disturb it. This will allow the government adequate time to investigate and to determine whether there actually is a differing site condition. If you fail to give timely notice, and you could prejudice your right to payment, because why? You're prejudicing the government's ability to investigate the situation and also determine, okay, how much of adjustment are you really entitled to? So that's why notice is critical with the differing site conditions clause. However, the law does allow you some time to work with the conditions before making notice, because you might go out there the first day and see something that's a little bit different, but when it comes down to it, after performing the entirety of the work or performing more of the work, you see that was just an incredible little anomaly and not a material difference. So you're not required to provide that notice immediately, but as soon as you realize the general nature of the work is different, then you have to provide that notice. And one thing, I know I've harped on notice a lot and the importance of it, but this is one time, probably the only time I'll tell you it's not always fatal. Why certainly it's not preferred or optimal route. If the government has constructive or actual notice of a change, you may be able to get away without providing notice because there was no prejudice to them. So the notice requirements aren't always strictly enforced if you could show that the government did have actual notice and they weren't prejudiced, but you don't want to have to be in that position. So provide notice as soon as you are reasonably confident that there's any kind of differing site condition. Another thing you want to make sure is do a site investigation if you can. It's not only prudent, but it's also, as we'll see in the next slide, it's often a requirement in contracts. Lastly, make sure to take into account publicly available information and your experience as a contractor. Remember, it's part of differing site conditions claim and ability to recover under the clause is that it was an unforeseen condition. If you're an experienced contractor, maybe that's worked in this building many times before, that some of that knowledge may be imputed on you. Say, oh, even though in this contract it wasn't set forth in the specifications you were going to hit asbestos, but you've worked in this building so many times before, it was unreasonable for you to say that you didn't expect it. You should have pointed that out earlier. So that goes to the unforeseeability of the condition. Site investigations. As we saw with the last slide, the government is going to accept the risk of a differing site condition, but at the same time it places an obligation on the contractor to investigate the site to mitigate that risk. The clause really requires you to investigate the site before submitting a proposal. for a contract. It makes you look before you leap into a contract. But it's not all bad. The contractor is allowed to, again, rely on the contract indications in the specifications. And it's not, again, required to verify the accuracy of all the information contained in it. But one thing is important: if you visit the site and you do believe maybe additional information is necessary or could help you or could help other bidders, it's not a bad idea to ask if you could perform additional investigations. Sometimes it might be denied. Often that request is going to be denied. But at least if you could say you requested an opportunity to do that, it might be helpful in the event of a differing site conditions claim. We had a contractor recently who was going to bid on a project, and it was a large area, but there was only one boring. For a large area, the contractor requested the ability to take additional subsurface investigations. That request was denied. Later, as you can imagine, a differing site condition was encountered on a spot far away from that one boring. So we put in a differing site conditions claim. There was an argument was made that, well, your reliance on one boring wasn't reasonable. You should have known that one boring isn't enough to consider the whole area. But the fact that we asked for additional investigation pre-bid helped us overcome that argument. Last thing, don't skip the site investigation. If you do, you could be assuming differing conditions that are plainly obvious at the site. So make sure you don't skip that. The next clause I want to talk about is the suspension of work clause. It provides the contracting officer with the ability to suspend or delay or interrupt any of the contract work during performance. But it also allows the contractor to be compensated for any delays or suspensions without profit, though, provided the contractor is not the cause. As with changes, there are directed suspensions and there are constructive suspensions. Directed suspensions are easy. It's a stop work order. Constructive suspensions are a little bit more, of course, more difficult to spot and aren't the result of a specific writing or direction. But in such cases, when there is a delay or suspension, it's the cause of government law considers that such a delay to be a constructive suspension, and even without the express order, the contractor may be entitled to receive an equitable adjustment for the suspension. We had a contractor client not too long ago. It was delayed significantly because, unfortunately, the agency didn't have enough personnel to review submittals. This prevented the contractor from going ahead and performing the work. It was delayed for more than 400 days, and although there was never a formal stop work order, because they were delayed as a result of something that wasn't their fault, they were entitled to recover an equitable adjustment. Notice, particularly important for constructive changes or constructive suspensions. Again, you have to provide notice when you're aware of a suspension or delay, and it's 20 days again. So you have that 20-day look-back window. So you're only entitled to recover extra cost incurred 20 days before that notice. There's another notice once the suspension is over, or the delay, when you consider the delay is over. You must also provide notice of the impact of that delay. Types of damages under the suspension clause. There are a host of them. Field office overhead, maybe you had to demobilize and remobilize. Those would be something you're entitled to. Equipment rentals, your subcontractor costs, markup on subs, and unabsorbed home office overhead are all types of damages available under the suspension clause. However, profit is not. Variation in estimated quantities clause, another important provision you're going to find in construction contracts. It's basically to protect the government and the, sorry about that.
We're now going to the cartoon portion of the presentation.
That's to wake you guys up from, to protect the government. So the clause protects the government and the contractor from potential losses or windfalls when there's an overrun or underrun in the estimated quantities. As a general rule, the clause is going to provide an equitable adjustment to your unit price, your stated unit price, when the actual quantity varies more than 15%, either above or below that estimated quantity in the contract. The recognized purpose of it, again, is to apportion the risk for unforeseen overruns or underruns. And just for example, from a contractor perspective, in the event there are fewer payable units, you might not be able to recover your fixed costs that have been allocated per unit, and you're going to have unrecovered costs. That's where the clause could come in and help you. Essentially, what the clause does is allow for you to adjust your unit price to prevent windfalls or harmful losses. I like to say it prevents you from making a killing, but also prevents you from getting killed too on the contract, or the same thing with the government. So it's a fair clause. It doesn't make you whole, though. It's only, because that first 15, it only applies to the units above 15%. So you're not going to be able to recover your costs for those units up to 15%. So that's an important thing to consider, and it's why this clause isn't always the best clause to proceed under if there are other options. I'll explain that in a second. Another important thing to remember is, and there's case law on this, the extra cost you're incurring per unit has to be, in order to recover it, has to be the direct result of the variation in quantity. If you're incurring additional cost per unit because of other things, maybe your own inefficiency, just because there's an increase in quantity doesn't mean you're entitled to readjust that unit price. You have to point to the specific fact that the increased variation or decreased variation is the result of your extra costs. There might be times when you could avoid or not necessarily apply this clause. If the original estimate in the contract was grossly in error or misrepresentation or just negligently provided, you're not going to be limited to the VEQ clause. You can move on. You could possibly get recovery under a different clause. And you might want to consider this because the changes clause and the different site clause, condition clause allow you full recovery. You're not limited to recovery beyond or below that 15%. Notice isn't necessarily required under this clause, but it's always a good idea to provide notice if you see an overrun or an underrun. And also by providing notice, you're protecting your ability to go forward under the changes provision or differing site provision if you feel that that quantity changed because of a change or because of a differing site condition. The disputes clause, this is going to come into play when there's a claim an REA has been denied. It provides direction for when the parties haven't been able to reach an amicable resolution on an issue. Often the first step that comes up is, what do I want to do? Do I want to submit an REA or a claim? There are multiple reasons why you might want to do one over the other. In general, you want to consider an REA when the contractor has a good working relationship with the contracting officer, or maybe the agency has already indicated a willingness to negotiate, or maybe already indicated that there's entitlement, you just haven't been able to get to quantum yet, or agree on quantum. But on the other hand, a claim might be the right way to go if you're at a point where you could tell the positions are fixed, or maybe you already filed an REA, or also if you're running out of time. There's a 6-year statute of limitations. If you're running up on that 6 years, you don't have time to file an REA and wait. You just got to file your claim immediately. Keep in mind filing an REA does not preclude you from filing a claim. Often you do both. There's no formal format for an REA. Just keep in mind there's a certification in the DFARS for Defense, Department of Defense contracts if you're submitting an REA. The claim, again, is a bit more formal. You have to have a sum certain. You have to have a certification that's in the Contract Disputes Act. It's over $100,000. And your claim is going to have more of a legal analysis in it as opposed to the REA. If your claim is denied, or if the contracting officer just doesn't get around to providing a response, you could deem it denied, and then you would move on to either an appeal before the Armed Services Board of Contract Appeals or some other Board of Contract Appeals, whatever is appropriate, or file litigation in the Court of Federal Claims. You also have the opportunity for ADR at any point in the process, generally after a claim's been submitted. We've had a lot of success using judges from the Armed Services Board of Contract Appeals as mediators. It's often a great way to go to avoid the cost of litigation. Default, this provision allows the government to terminate a contract in whole or in part if the contractor is not performing the work on time or not doing the work properly. It's certainly a harsh action, but it shouldn't come as a surprise. The government's required to provide multiple notices before terminating a contract for default. These are known as maybe a cure notice or a show cause letter. If you get one of these, it's important to respond to it quickly, but thoughtfully and carefully, and also consider engaging counsel in the response, because there could be very harmful consequences of having a termination for default on your record. If the government declares a default, of course, they're entitled to complete the project using your equipment, your materials, and they're entitled to any additional costs that they've incurred to complete the job. But the clause does provide reasons why the government cannot default as well. Let's say acts of God, fires, floods, strikes, other government actions, or even unusually severe weather. If you could show that one of these events is causing your problems, your delay, your failure to perform, a default isn't appropriate. If you are experiencing one of those types of events, you do have to provide notice to the government within 10 days. Terminations, we just spoke a little bit about the terminations for default, but it's also important to know that there's terminations for convenience. The government has the ability and right to terminate a contract whenever it believes the termination is in its best interest, whether or not there is in fact a default. The government may terminate part of it or only part of it for convenience, and may do so at really any stage in the contract. Fortunately, though, such termination is not going to be a black mark on your record, and it's not going to affect your past performance ratings. As with other government actions, termination for convenience can be constructive or it can be directed. If it's directed, that's easy. You get a letter from the contract officer telling you your contract has been terminated, submit a proposal for settling out your costs plus overhead and profit on the work you've done so far. Constructive termination for convenience, you hardly ever see them. Only time I've ever seen one is where a client requested direction from a contractor for literally years on how to proceed with the next step of work. We're never provided direction and filed a claim for constructive termination for convenience. Termination for convenience isn't that bad. It's really an equitable way to make the contractor whole. There are some alternatives for termination for default you want to consider because it is such a drastic remedy. If you can, try to work with a contractor to figure out, okay, maybe I could bring in a subcontractor to perform more of the work. Maybe I just don't have the manpower or the resources to do it, but keep the contract with me, and I will increase a subcontractor's role in the project. That way, your experience and knowledge stays, and the government might appreciate that. You could also consider changing the schedule if you have a good amount of time. So that was a quick run through. I know that was fast, but these are the clauses we feel are most important. As a more general comment, the better you understand these FAR provisions, the more likely you'll be able to resolve the problems before they happen. So again, key, documentation and notice. Act as if you're preparing an REA or claim all along, and the irony of that is if you do that, you're more likely to avoid the claim in the end.
Thanks, Bob. All right, so I want to pick up on pass-through claims, but I just wanted to, I guess, build off of what Bob just said real quick. When you're talking about all these clauses, I know it's a lot of information and it's dense coming at you, and probably the things that you heard over and over again were, as kind of Bob said in the introduction, notice and documentation. And for those of you who are already my clients out in the audience, I'm sure you're very sick of me hearing me say notice and documentation. But there's a reason for it. It's, as Bob said, a lot of times if you are aware of the way the clauses work and aware of what the government is looking for you to do, you can avoid confrontation. And I think one of the biggest misconceptions that contractors have is that, if I'm documenting, if I'm always in the mindset of like, oh, I've got to keep myself ready and preserve my rights for a claim, isn't that being combative? Isn't that being, needlessly litigious? And the answer is no, because you don't have to do it in a combative or aggressive or, assaulting, litigious way. It's a matter of making sure that the documentation and the notice are given so that everyone's on the same page, and that's going to promote and foster, communication between your contracting officer or whoever you're working with at the agency, and it's going to allow you to avoid claims. Now, tying that back to what we talked about from the subcontracting point of view, the more aware you are of the clauses and the various machinations that you go through when you're trying to give notice or documentation, whether you're a prime or a sub, it's going to better inform your negotiations about how to set up your subcontractor. If you're a prime and you understand, I have A, B, and C that I have to do to be able to make a claim later under a changes clause or be able to negotiate with the government about a change or whatever, you're going to be able to bring that to bear with, your discussions with your sub. And the same thing from a subcontractor's point of view. So the more familiar you are with all of these clauses, it's going to make you be able to do your job better, but it's going to make your interactions with your prime or sub, depending on who you are, easier. And a lot of the times what you're looking to do eventually is to set yourself up to do one of these pass-through claims. And for those of you who've never heard the term pass-through claim, it's basically a type of claim that the prime passes through on behalf of the sub. And just quick housekeeping note, I've noticed a lot of you taking pictures. If you come up afterwards, just give me your card. We're happy to share the slides with you, answer any questions you've got. So feel free to take pictures, but if you want the slides afterwards, just let us know.
And actually, they're all on the
on the
flash
flash drives, and we have extra.
Take them home and look at them.
All right, so in the context of these pass-through claims, the reason that these pass-through claims exist is because of a concept called sovereign immunity. And many of you might have heard that term before or are aware of the concept, but the general rule is you can't sue the federal government, right? So there's all sorts of situations where, sovereign immunity comes up, but But generally speaking, you're not allowed to sue the federal government, can't fight City Hall type thing. There is, of course, an exception if you are doing business with the government. Under a statute known as the Tucker Act, if you have a contract, implied or actual, or in fact, with the government, then you're allowed to, sue them or enter into a suit or enter into a dispute the same way you would with any other party. But notice that that says if you have a contract with the government, which means that if you're a prime, you're covered. You can sue the federal government because the Tucker Act says you can, you have a contract. If you're a sub, you don't have what's called privity of contract. Your contract is with the prime. The prime is then contracted with the government. So you're not under this Tucker Act umbrella. You're not under this exception. You can't go directly to the government and say, hey, I had a change occur, or I had a differing site condition, or I think there was a defective spec. Even if it's as a subcontractor, scope of work, you need to pass that up through the prime contractor. Now, that means that the subcontractor needs to put the claim together, but the prime needs to sponsor or pass that claim through. Prime has to actually clearly and affirmatively agree to sponsor the claim. Sometimes primes refuse, and we're going to talk about why that might be justified in just a minute. But a lot of times what happens is, for those of you who've ever done a claim or dealt with the disputes, and again, it's one of the reasons we went over the disputes clause, it's an important piece of how you deal with and hopefully resolve, not just get litigious and fight it out, but resolve a dispute, is going through the disputes process, which is consistent with the FAR disputes clause, which Bob talked about, and the Contract Disputes Act, the CDA. You'll hear it termed sometimes. Now, the problem with that is that sometimes the CDA process, from especially subcontractors that might not have as much cash flow coming through and might not have the ability to self-finance while issues are going on, takes a little bit of a long time under the CDA. And so a lot of times what you'll get is that there starts to be tension between the primes and the subs while there's the pass-through claim being litigated between the primes and the government. So it can be a huge source of prime subcontractor conflict. And there's a couple reasons for that. One is what I just talked about, the timing under the CDA. Maybe the subs aren't as familiar. Another reason to really talk when you're negotiating your subcontract about the disputes clause, about how long resolution might take, about how to deal with these pass-through claims. But the other thing that the prime can be concerned about is, for those of you who have ever heard the term FCA, False Claims Act, fraud, any of those fraud-based statutes that the government is, pretty big on enforcing for good reason. If you sign a certified claim, even if it's your sub, put it together and said, I know you need to pass it through, here's my claim, pass it through, please. If you then certify and pass it up and there's fraud or there's something incorrect that your subcontractor did, you can be on the hook for that because you're the one that signed it. At the very least, if you combined it with one of your own claims, you might have just forfeited your own claim. And again, it's all about the government. If you're the one responsible passing it through, you're a gatekeeper. You've got some responsibility. So a lot of times when you're talking about, how can conflicts arise, the primes are going, well, I need some safeguard that if I take your claim and pass it through, I can trust you and I'm not going to get, dinged on the upstream side with the government. Meanwhile, subs are going, well, that's great. I understand that you want some protection, but what's my protection if I say, here's my pass-through claim? I don't have the ability to go after the prime, the government myself. And the prime goes, yeah, I don't really feel like doing that, sorry. And it happens both ways. So these are the things that are always going to be at the forefront of, your counterpart's mind when you're negotiating a subcontract. How do you balance those things? What we usually try to do, and again, if you've got questions and if you have specific concerns, come talk to us after and we can talk to you about your specific situation. But generally, try to assuage the prime's concern by putting something in your contract about, these are the conditions that the sub needs to meet. They need to do A, B, and C in order to make sure that, it's acceptable for you to pass it through. And for the subcontractor's point of view, put things about, what conditions the prime has to meet. As long as you meet the conditions 1, 2, 3 that I just said I need from you. If you sign a certification to me and you indemnify me for any damages that I have upstream, maybe I'll pass through whatever you give me as long as you meet those requirements. It's all about negotiating to kind of assuage those concerns and hopefully make sure that everybody's okay. So in order to do that, subcontract clauses should address explicitly, not just flow down the disputes clause, but involve yourself in discussions between the prime and the sub, address specifically how pass-through claims are going to be addressed, talk about each party's responsibilities, talk about the difference between a subcontractor's claim that the prime is going to pass through because it's against the owner, against the government, as opposed to or in contrast to just a breach of contract between the prime and the sub, and also talk about who's got the ability to be the final arbiter of which one of those buckets something goes into. That can be an area of dispute. There's all sorts of permutations that flow from this, but this is kind of the general concept that you need to be aware of and try to flesh out. Also, what you might want to do is enter into something called a liquidating agreement once the actual pass-through claim is ready to go. And that's a whole separate agreement that talks just about how the pass-through claim is going to be litigated, who's going to pay the costs, who's got veto power over if the litigation continues, et cetera. And again, disputes clause should always kind of differentiate between, okay, I'm a sub, I've got a claim against owner, I need you, prime, to pass it through, and I'm a sub, I think you, the prime, did something wrong. It's not the owner didn't do anything, we've got a problem, and that's just a breach of contract under our contract. And there's always going to be a little bit, or not always, but there's often going to be a little bit of conflict about who thinks what. A lot of times subs might think or might not be sure if it's a conflict with the prime or if it's something that should be passed through. And that's something you're going to want to address. You're going to want to address what happens if the prime refuses to honor the subcontract. That's a big area of breach of contract cases. In other words, not only to say, you know, hey, you need to pass this through, but what happens, what are my remedies under the contract if you don't pass it through? How do I go after you for breach of contract? These are other issues that you need to be aware of. They come up all the time. I mentioned before, pay if paid, paid when paid. You guys might be familiar with those terms. It's a state-to-state thing. They're enforceable in some states, not enforceable in others. But obviously, if you're a prime contractor, one of the things you might want to do is say, if I'm not getting paid by the government, I'm not paying you guys, subs. Subs, you want to watch out for those clauses because maybe you don't want to agree to that, especially if you're tied up in litigation. Notice, waiver, and release, that's all the documentation and notice stuff that Bobby was talking about. That's why it's so important. It comes up here too. Exhaustion of administrative remedies, that ties back to the CDA claims. If you're prime, you need to go through that process of submitting a claim. You just can't go straight to litigation. And of course, ADR, another way of avoiding prime subcontractor conflict a lot of times is to have an ADR clause. Then we're going to just spend real quick on what your other remedies are if you're not talking just prime sub, and then we're going to leave some time for questions. I think we've got until 4 in this room, so we'll stick around longer if you guys need us to.
Okay, a final remedy that might be available to a subcontractor is a remedy under the Miller Act. This would be in addition to what Maria talked about, pass-through claims or direct claims against a prime contractor. It just provides another avenue for payment for a sub. As Maria mentioned, the concept of sovereign immunity prevents the government generally from being sued, and it also prevents you from filing a lien or asserting any kind of lien against its property. So unlike private projects or even some state projects where liens are allowed, you can't place a lien against the property to protect your right to payment. But in order to give a subcontractor a little bit more protection, realizing that you can't lien, the Miller Act was enacted as a substitute to provide subcontractors with another avenue of payment. And what the Miller Act basically does is it requires, among other things, prime contractors to provide bonds on project, payment bonds and performance bonds. Not necessarily required on overseas projects. Sometimes they are, but sometimes due to the location, it might be hard to get a surety bond. But in those instances, we've either seen no bonds or at all, or maybe the government will allow a bank letter of guarantee to substitute because they might be easier to get, and that could provide some contractor, or at least the government, with protection. The Miller Act applies to all projects for construction, alteration, or repair for any public building or public work where the prime contract exceeds $100,000. One misconception about Miller Act claims or bond claims, as they're referred to, is they're not brought against the prime contractor. They're brought against the surety directly in the district court, the United States District Court, where the project is occurring. So you may file a lawsuit against the prime contractor in conjunction, or you may not. You may not want to get involved in a multi-party litigation with the prime and other subcontractors, or maybe your contract with the prime has an inconvenient forum somewhere where the prime's located. You don't have to go that route. You may be able to just go against a surety on a bond claim and not present a claim against or lawsuit against the prime. Just some general things you have to remember for perfecting a Miller claim, a bond claim under the Miller Act. If you're a first-tier prime subcontractor, that means if you have a contract with the prime that provided the bond, you don't have to provide any kind of notice ahead of filing a lawsuit. But you do have to wait 90 days from when payment was due before taking any kind of action like filing that lawsuit in the district court. But you must file that lawsuit within 1 year of the last day that work was performed or material was provided. And just one caveat with that, last day of work performed or material was provided, it's contract work. It's work required by the contract, not punch list work or repairs that you had to go back and make.
Or warranty work.
Warranty work. That's, you can't use the date of that. You have to do the earlier date of when you last performed contract required work. For second-tier subcontractors, same requirements, except you are required to provide a notice. And that notice has to be provided within 90 days of when you last provided work. Your notice has to have substantial accuracy, name of the party whom labors and services provided, and that you're going to be making a claim against the bond's principal. Lower tier subcontractors and suppliers don't have lien rights, unfortunately. The Miller Act is very specific on who does and who can't pursue a Miller Act claim. And they've strictly interpreted the word subcontractor when defining a second-tier claimant, and the parties having a direct contractual relationship with the supplier to the contractor furnishing the bond have been denied the Miller Act remedy. As far as defenses, again, when you're bringing a Miller Act claim, you're filing a lawsuit against the surety. But that surety can step into the shoes of the prime contractor and take whatever defenses that prime may have had and use them against you as well. So if you're a subcontractor and you breach the contract, the surety is allowed to bring that up against you. If the prime is entitled to set off a recoupment for other problems on the project that they believe the subcontractor is responsible for, they could use those instances, the surety can use those instances to set off any claim you may have for payment. And if you fail to mitigate problems on the project as a sub, the sub surety can use that as a defense as well. So with that, we'll be here to certainly answer any questions. Like I said, we have the presentation on flash drives down there, our cards and pamphlets, so hope that wasn't too scary. I know it's Halloween, but hopefully it made it a little easier. Okay.
All right, sir.
So as a prime construction contractor, what FAR clauses should be flowed down in full?
Honestly, I would say, and I don't know what your opinion is, I think it depends on the contract. I mean, I think there are concepts that you always need to cover. I think changes, disputes, suspensions, terminations, all of that, you definitely need to, and terminations for convenience, you need to flow those down, suspensions, not necessarily in full text. I think it's up to you. If it's going to be whether, how much wiggle room you want to leave yourself, how much wiggle room on any particular issue you want to leave your sub. I don't necessarily think that it ever behooves you to just boilerplate flow down something verbatim. I think it always makes sense to think about conceptually, unless it's a mandatory flow down clause, in which case you have to flow it down, but there's not a huge amount of those in construction. I don't think there's any set rule. I think it's always going to depend on what you need, what your subcontractor needs, what's good for the project and your partnership at that time. I think it's just a list of concepts you need to cover, and I think those are all the critical issues that we talked about with regards to the clauses that Bob went over.
And you also want to consider the sophistication level of your subcontractor too.
Yeah.
Some of the FAR clauses say the content of this clause shall be flowed.
Yeah, I mean, in that case, you have to then flow down, I would flow it down verbatim, so. Is there a question in the back?
Yeah, a few slides back related to disputes.
Mm-hmm.
REAs versus CBAs. The last bullet on that was must proceed diligently with work. A few slides before that, you had said on kind of a similar topic, stop it. So I'm just wondering what's, like if you're in that kind of environment where there's a bunch of work and you can see it's not right, would you stop or do you proceed diligently with work?
So I think the context where you heard the stop work was probably in either the suspension or the termination stuff that Bob was talking about,
And
because.
the differing site conditions, that you're specifically
Yeah.
required to stop work in that instance. That's a subset of an issue when you hit a differing site condition, because you need to stop. You need to allow the government to go in there and really assess, is this a differing condition? If it is, what's the extent of it? Because without doing that, if you just go plow through ahead with the work and then make a claim later for a differing site condition, the government never had an opportunity to really consider, okay, how different was this and how much did it really impact you? So
Yeah, so it's going to depend on the context in which the issue comes up, and generally speaking, if you're the prime, whatever the contracting officer tells you, if the contracting officer says, look, we don't think it's a change, or we don't think it's a differing site condition, keep working. You can't just say, well, I'm not working until I get paid. So that's the proceed diligently with the work part. You can't, whereas sometimes with subcontractors, if you've got certain stuff in your, contract, depending on what you've negotiated, you might be able to say, well, I'm not working until I get paid. Prime contractors can't do that when they're working with the federal government. It gives them a basis to terminate you for default. So you've got to stop when you know certain issues come up under certain clauses. You've got to make sure you understand when you have to do that, what issues trigger that kind of responsibility. But basically, unless and until that kind of situation occurs or unless instructed differently, you're supposed to be proceeding diligently as if you're completing the contract. And if that means that there's a differing site condition or a change and you think you're entitled to more money, you start tracking those costs and you make a claim. But you can't stop work, and you've got to keep proceeding diligently. You're not able to stop work while you litigate whether there is a differing site condition or a claim, et cetera. Any other questions? Yes, sir.
I was a subcontractor on a renovation, and the prime didn't pay me. I notified them within 90 days, and I wasn't getting paid. I started sending emails. But when I filed with the bond company, it turned out the prime wasn't the prime. They had a teaming arrangement. I thought they were the prime contractor, but they weren't. And they did not, and the bonding agency denied my claim under the Miller Act because I didn't notify the prime contractor.
So you were actually a second-tier sub, you mean?
Second tier and didn't know it.
That's interesting. I mean, I think that there's probably, I would have to look at your documents, but I would think that there's probably some creative way to still go after the prime for failure to, open and honest communications, good faith, fair dealing, something like that.
You may have lost your
Yeah.
right under the Miller Act, if that's really the case, but you certainly still have rights directly against the prime.
The amount wasn't worth
Yeah.
That happens.
litigation costs, but it's still paid.
Again, always back to that open and honest communication when negotiating your subcontract, although that, you have to trust that the other person is also openly and honestly negotiating. Any other questions? Yes, in the back.
Yeah, we have all this issue that was sort of being trumped with the president with all these tariffs that are coming in. We've seen it in Canada and Mexico where, wood, for example, he talked about tariffs, wood costs went up 70%. But they never happened. There never was a tariff, and now here's a new one, and all of a sudden all of that disappears. We're looking at the same thing happening in January. How's all this, I mean, we cannot anticipate, I don't think anybody can anticipate what our president is going to do. He seems to be very, you just don't know what he's going to do next.
Yeah, and I think the way that sorry, I didn't mean to cut you off. I think the way in which various actions of different administrations or, other things that just happen around the world can impact cost and pricing, especially if you're doing work overseas. We do a lot of work with contractors that work in Afghanistan and Iraq, and I've got a project in Portugal right now. I think it's, again, all about understanding what rights you have. So sometimes, for example, something like that can cause a delay in the delivery getting to you, and maybe that's an excusable delay, or maybe it's a compensable delay. It's all about understanding the FAR clauses and trying to figure out, using professional legal help, which of those clauses you might be able to squeeze under and say, okay, well, now all of a sudden wood is X amount % more expensive. If I had to order that later than I originally was going to have to order it, do I have a right to a request for equitable adjustment, et cetera? So there are different theories and different strategies you can use, but yeah, I think work in the federal marketplace is, exciting, and there's a lot of reward to it, but there's a lot of risk and there's a lot of uncertainty because you're working with the federal government. They've got a lot of resources and stuff changes. I think that's just the way it is sometimes. It's just about understanding what rights you might have, to try to recoup the difference. Anything to add there? Yes, ma'am.
When you're talking about a notice for anything really, I guess specifically like a constructive delay, what all do you need to include in? I mean, how do you notify the government in the best way?
I'm sorry, you went out a little bit there. Are you just talking about what kind of notice you have to provide when there's a delay? Sorry, I don't mean to single you out. Somebody walked by.
When you're talking about a constructive delay, where it's not really directed by the government, it's just something you're noticing is happening, what all do you need to provide? I guess obviously you have to notify the contracting officer and then really the whole team, but what exactly do you need to, how do you meet that requirement that you're notifying them?
Sure. I mean, what we usually do is that you should, for those of you who've heard the term serial letters, they're a good thing to do. And I think in 2018, and with the advent of email, you fall into a habit where you think just firing off an email to the contracting specialist or the, you know, the COR or the COTR on the site is enough. I think the more you put it in a letter itself, in a serial letter, send it, I mean, email it also, but put it in a formal letter, have a file where you keep all your serial letters, say what's happening, that you think it's causing you delay, that you think there are going to be other issues that stem from it, if the case may be. If you talk to a legal professional, or if you guys in-house are able to figure out the delay is caused by this, that therefore it fits under this clause, or this clause, or this clause, you know, mention that in the letter, and then say, and we reserve our rights to do whatever we need to do within, you know, our rights under law and equity as it goes forward, and, you know, we're happy to discuss this with you at your convenience. It's really just about making sure that they know what's causing the delay, that there's a delay, that you're reserving your rights, and also that you're open to conversation, because you don't want to make this necessarily litigious. It doesn't have to go that way. You want to resolve it.
I've got a VA, private VA notorious for delays, and one of them we encountered conduit in SLAS. We didn't expect to be there, we expected,
Yeah.
there it was, and that caused the project to stop, because we needed to reroute conduit where that power was supplying.
And you sent in an RFI and they didn't answer it for 2 months?
Answered it, said yeah, and so would it be appropriate to submit that? I would notice that in different site conditions, you don't get profit because of delays.
Different site conditions, you can get profit.
Yeah, it's suspension that you
where
don't.
Oh, is what?
Suspension, that you don't get profit, yeah.
Yeah, that was my question, is there a better, you know, should we be selecting about what clauses we might submit under? Should we reference a FAR clause when we give the delay notice?
I think to the extent that you feel certain, yes. I mean, when we've got clients that come to us at that stage, you know, sometimes there's an alternate argument. We had a case recently where the way in which a problem happened, it was a dredging case. It was a defective spec, it was a differing site condition, and it was a change, like all rolled into one. And we said all three. You know, we said, we're still evaluating what the total amount of damage is and what the total impact of this is going to be, but we reserve our rights, and we specifically note that, you know, there might be claims and these are the issues. And a lot of times if you do that, then if you can sit down with the contracting officer and say, okay, well, here's what we would need to do, then you can work something out that it doesn't result in a claim later. Again, open and honest communication, not only between subs and primes, but with the government as well.
The contracting acts I'm currently dealing with are very reasonable, but in the past,
Am I missing people that you're saying?
I don't think so. Any other questions right now?
Sorry, I didn't mean to.
So I had a job that I did for the Army, and when you talk about delays, you put in conditions down and put them in the tank. And I filled out the conditions down, I put it in, I gave them all the information, and then I waited 5 months. So I mean, I still had equipment there, I mean, and I couldn't get back to the now it's 5 months and this much more.
Yeah.
So how do you deal with that?
It depends. Again, I mean, sometimes if you've got an attorney that can come and start saying, like, I represent this person and, you know, we're monitoring this and we'd like to work it out, but if we don't hear from you, I don't want to go this route, but then we're going to go to a deemed denial stage, or we're going to go to an actual claims or litigation stage, depending on where you're at in the process. Sometimes that shakes something loose, sometimes it doesn't. It's just a question of, you know, it really depends on what agency you're dealing with, what individual you're dealing with. And unfortunately, there are delays, and I think part of it is you got to kind of build that into the process. It's unfortunate, yeah. I'm sorry? I've seen longer than that. I mean, I think the key is you probably want to take a hard line and start saying, like, look, you're leaving us with no choice. We want to work this out amiably, but I can't get a response. And I'll tell you, sometimes also it's a question of they want you to go to that next level, because then it puts it in their legal department's hands, and then they can have their legal department deal with it, because they might just be that they're spinning their wheels and they don't know what the right thing to do is, and until you've got a certified claim, they can't get it before the people they want to get it before. All right, for those of you who have additional questions, we will stick around outside, but we've got cards up here, we've got flash drives up here, we've got a little brochure, and we are at booth 824. Please stop by. We will have frosty beverages flowing freely starting at 4 p.m., so come partake in the holiday spirit. Happy Halloween. Enjoy the rest of the conference.
All right, thank you.